Hey everybody, Bill Sack here, Director of Legal Operations with the Second Amendment Foundation. Just 2 weeks ago, we were dealt the difficult-to-swallow denial of cert in SAF's Maryland assault weapons ban case, Snoke v. Brown. But, as we spoke about last week, there was plenty of silver lining to that denial, including the indication that SCOTUS would presumably take up the issue in the next term or two, once the circuit courts had had more time for the issue to percolate. Well, this week, we may have learned exactly what percolation the justices were looking forward to. The Trump administration filed a landmark amicus brief in Harrel v. Raoul, our case challenging the Illinois assault weapons and magazine capacity bans, supporting SAF's position and proclaiming clear as day that the United States' position is that these bans are unconstitutional. In what has felt like a repeat of history for many of us gun rights activists, just as multiple circuit courts refused to properly apply Heller, and instead made up their own interest balancing test, only to then be reprimanded and corrected by the Bruen decision. Since Bruen, some of those same courts have once again refused to heed the binding demands of the Supreme Court and the Constitution. One such circuit court appears to be the Seventh Circuit, where the Harrel case now resides. In an early preliminary decision, the Seventh Circuit held that AR-15s and the like are not arms under the Second Amendment because they are, quote, too militaristic, unquote, a test that is found nowhere and that the court apparently invented from whole cloth. The government's brief filed last week admonishes the Seventh Circuit for their refusal to properly apply Bruen and strongly advises that they reverse course and follow the law. SAF strongly agrees. Heck, that's what we've been saying all along. So now all eyes are on the Seventh Circuit. Will they follow the demands of the law, the Constitution, the people, and the administration, or will they remain defiant and continue to thumb their collective nose at their constitutional oaths? Stay tuned here to find out. I'm Bill Sack, Director of Legal Operations with the Second Amendment Foundation.